we're defaulting so many people or getting them precluded from testifying that like they're not even getting to that because we're just knocking people out early in the case.
I don't see that a lot. So that's a pretty aggressive approach that you're taking. That I mean, I really haven't seen much of it as of recent. So it's working for you.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, everyone. Welcome to this episode of The Defense Never Rests. I'm your host, Megan Henry, and today I'm joined by an old law school classmate and friend of mine, Dave Kwalter. And Dave is a plaintiff's attorney, and I love having plaintiff's attorneys on because I like the perspective they can give to us on what things that they look for and what they're looking for with their interactions with claims adjusters or defense attorneys, and practices and tactics that we do that help move the case along or cause headaches, or what we can do to, have a smoother resolution, or just how to navigate a case with them and what they're looking for. So Dave wanted to come on and talk about it. So let's bring him in. Good afternoon, Dave. Welcome to The Defense Never Rests. I'm so happy to have you.
Yeah, thanks for having me. I'm excited to be here.
So for our listeners and viewers who likely don't know, I've known you for a long time. We went to law school together, and we actually worked together briefly in the depths of contract review way back when.
That was a crazy job. That was actually a lot of fun. I forgot you were there. You must not have been there that long. You must have bounced early.
I don't know. I think we bounced. I think we probably both got out around the same time. But it was, I would say it was an interesting experience to do contract review. It
was fun in the sense that your only job at one point was to not fall asleep. Like you could stay awake because you remember there was times where like they didn't have any work for us, but they still wanted you to be there, but like you just couldn't sleep. So you had to be there, you had to be available, but just awake, which some people couldn't manage to do.
And it's a very humbling experience to be treated as if you are like less of a person than anybody else on the floor.
Maybe I wasn't that. Maybe I might have been less of a person when I was younger. It was crazy. I remember there was a game they were playing like Risk, and there was like Risk is like a long game, like, and there was this extravagant table of like Risk playing that went on for weeks because we had no work. We still had to be there for like 40 hours. It was crazy.
Oh yeah. I remember watching like movies, but then you weren't allowed to have phones, or I think that was a time of Blackberries. So
yes,
but of course everyone there is looking for like a quote unquote real job while we're, contract attorneys, but you need your Blackberry to like follow up if anyone emails you back to like the probably hundreds of resumes you're sending out. It was a real just humbling experience. To say the least.
Remember they had like a computer lab. They had like a computer, like an internet like cafe thing at the end of the hallway, and you like had to like reserve time or something. You could only be on there a certain amount of time. It was crazy. There was one guy who worked there who I saw the news representing someone in a criminal case that was still working in the contract. Like he was still showing up for doc review, but also like on TV for representing someone in a criminal case. It was wild. The characters there were wild. Mm-hmm. It was very interesting.
Yes, I think like you're in such close quarters with people and you spend so much time with them. I just remember hating anyone who sat around me, you'd be like, oh, they click their pencil. Yeah. Like I'm gonna, Sandra's driving me crazy today, or she's eating that apple too loud.
Right. Eating was like a big issue because there's like people are eating there all day, just like snacking. It was gross. I remember at one point back to when where there's no work, I never read so many books. Like I read a book about bananas, like the banana trade. I read all these books. I was never more well-read than when I worked in doc review.
And the thing is, there's some people that we went to school with who've made like very successful careers in that space.
Yeah.
Which is impressive. Like, I good for them because I mean, there's a certain sect that's a huge part of, review, like discovery review. It just isn't where I'm working now.
I mean, that's a massive job when you're managing that. Like, you remember how many people, there were hundreds of people on that job. Someone had to manage that. That's a massive undertaking to manage the work of 300 lawyers or 400 lawyers or whatever. It's a lot. So yeah, I mean, I know who you're talking about. And Yeah, it's wild. I think that was a newer kind of niche too when we were
Yes.
getting into it, and they kind of just hit it and timed right. And now they're, I think, like partners at firms that only
Yeah.
do the doc review, like
Yeah.
specialize in managing that part of it.
Yeah. It's pretty awesome, which, you know, if you had told me that would happen going into that, I would have never guessed it.
No, I would never manage anything like successful coming out of like doing anything that we were doing in that job.
No.
Like other than like maybe someone became like a really good writer or like, but not law related.
No. Yes, exactly. They read enough books like you. They're like, maybe I'm just going to pen my own novel while I'm sitting here waiting for something
Exactly.
to do. But I want to back up a second though, because, you know, we both went to Villanova, and did you intend, like when you were in college, was law school your automatic next step? Was it something that you were planning on, or is it something that you kind of fell into because you didn't have another plan?
Yeah, I think kind of a combination of both. At one point, I was like really into like Jerry Maguire, and I wanted to be a sports agent, which is
Sure.
probably like half the guys who went to law school or gals who went to law school. And then like did horrible in school and had to like really get my grades up and test okay to get into law school. But yeah, I kind of had a plan that I was going to go to law school from early on in college for a different
Yeah.
reason than what I'm currently doing, obviously.
Oh, so what was your reason? Was it the Jerry Maguire reason, or
Yeah.
you? Oh, okay. I mean, I have to say, I did share that desire. I remember going into law school wanting to be like some sort of sports agent. Like I don't. Maybe it must have been the time, because I feel like we had a lot of classmates that also had those same aspirations. So it must have been the Jerry Maguire movement or something of that sort.
You know, what's interesting to bring it back to the doc review. One of the guys who sat next to me is actually an NFL agent, and he was
Really?
representing.
Wow.
Yeah,
How
he
about
actually
that?
he was doing it while we were doc reviewing, but just kind of getting it off the ground. But now he's got a nice business.
Well, good for him.
Yeah, pretty crazy.
So, you know, I kind of fell in the doc review experience because the law firm I had summered at, I summered there, and then they decided they're not taking any summer associates, and then they thereafter got acquired by some other firm, and I probably would have gotten laid off had I gotten the job. But the time I had no job, so that was my only option. The job market was crap. You know, what was your experience? Was it similar to that you had to kind of bide time until you found something else?
Yeah, same exact thing. Like we passed the bar. I think the week after we got the bar results, I got hired by whatever company that was running the doc review, and I just needed the money. So it was basically like just get money in the door while I find something else. But I really had no idea what I was going to do or what I wanted to do anyway. I was really just any legal job I would have accepted.
Yeah. And I mean, I remember for myself, like I never thought I'd be in litigation. I kind of fell into litigation because the economy sucked, and in bad economies, litigation is always active. So that's kind of how I fell into it. Did you have a similar experience?
Yeah, I'll tell you, like so my first job, I worked at Rand Spear's office. I never heard of Rand Spear, which is kind of wild if you're in the Philly market because he's a big advertiser. I never heard of him. I didn't know like a whole industry existed on representing people that were hurt. Like that didn't even cross my mind as like a job that existed, not the plaintiff side or the defense side. So I just like saw an ad, I applied, and then he hired me, and that's what I did, which is good luck for me because I think it was where I was supposed to be. But I had no idea. I took the first job that I got.
Yeah. And I don't know how much you can talk about your experience there, but I mean, I a lot of us have dealt with Rand Spear, and that office has a unique way of, I think, staffing cases. So how was that learning experience to you? And if to the extent that you can talk about it, how was it?
So I looking back at Rand's office, it's a great training ground for if you want to be in personal injury. We always say, Jason and I, that it's like the DA's office for like personal injury. Like you're in court all day, like your first day there, you're doing deps, you're going to ARBs, like you're trying cases. And now kind of our mentality with hiring new people is we want people that have worked in that environment. So we've actually hired 2 lawyers that are ex-Rand, our Spear Greenfield employees.
Yeah.
Because we know you're doing so many deps, so many ARBs, trials, expert deps that like you've done these reps, and maybe you're only a few years out, but you have like the experience of a 10-year veteran.
Yeah. I mean, that is true. I just remember having on the defense side getting being so frustrated when you want to talk to somebody, like you actually want to talk to somebody that's handling your case and you couldn't find anyone to talk to.
Yeah. Well, part of that is you're just so busy there.
Yeah.
That you're just like an average day at Rands is like a dep at 10, a dep at 2. So you're prepping your dep, you're doing the dep, you're hoping to eat something in between the prep of your afternoon dep. So like just getting the phone is just like, you're just running around like crazy. But I mean, they're pretty organized and they have a reason why they do things, which is it's just very busy.
And how long were you there for?
I was only there for less than 2 years.
Okay.
So I left there. I went to Craig Altman's office, which is a smaller PI shop, and was there for like almost 5 years.
Yeah. Well, I remember, I would see you in court quite frequently. And I remember you telling me, I think after you left Rand Spear's office, that talk to me how like working at Rand Spear's office also kind of taught you how to, or gave you an idea how to run your own law practice successfully. And am I remembering that correctly?
Yeah, I mean, to a degree. I mean, so there's a lot of things that they do. They're very system oriented, which we're like system oriented to like the nth degree. We are like all systems. Everything is done for a protocol. We keep stats and KPIs on almost everything that we do, which the basis of that we learned at Rand's office, and we just kind of added our touch to it. And we always say we put it on steroids. We do that, but on steroids. So we're like, if you don't have our discovery within 10 days, you're getting a 10-day letter. There's going to be a motion filed. It's automated. There's no extensions. We just do everything. And it's just, the reason we do it is because it's easier for us to keep track of it. If we start getting extensions and changing our deadlines, then like now we have to refocus our whole machine. But part of that we learned from Rands for sure. Yeah.
So, okay. So let's back up though. So you started your own firm with Jason Manis, who you guys worked together at Rand's office, right?
Yes.
Okay. So how did you two come together to decide to open up your own firm? Because that's a huge step and you did it pretty young. I mean, you guys aren't old, you know?
No, I don't think so. Not quite. Yes. So Jason and I, we met at Rand's office and then we became like best friends as working there. And then we continue to be best friends since after leaving Rand's. He left Rand's and went to another firm. And then at some point which a lot of people you're going to talk to that are in plaintiff side run into maybe a issue with how they're being treated at their firm. And if you have enough of your own business, you can make the decision to go on your own. So Jason and I both kind of ran into the same kind of issue, and not that they're entitled to make the decision because they were the business owner and we're all friends, but that I made a decision that wasn't going to work for me. And Jason did the same thing. And we had always talked about maybe partnering up. Luckily, when we came together, we had a similar idea how we wanted to run the firm. And then almost as most importantly, we had similar amounts of cases. So it made it easy to be partners because like we kind of were coming in even, and then we did it. So that was about 7 years ago.
That's awesome. Well, congratulations to both of you.
Thank you.
And, and now that you're working together with your best friend, how is that with like your relationship? Like, do you leave your friendship outside of work? Like, I can't imagine.
No. So we kind of compartmentalize stuff here. So Jason is mostly like litigation and handling the file, like the cases that are in litigation. I mostly focus on like kind of management and other things. So we stay out of each other's way in that respect, but we also talk all the time on cases. We have a similar view on how the cases should be run. And we've never had an argument ever.
Wow.
Yeah.
That's amazing.
Yeah. I mean, we both kind of agree that like everyone's trying to do what they think is best for the firm. And maybe you don't necessarily agree with what they think is the best for the firm, but you can still agree that they think it's the best for the firm. So, we can try it.
Right. And it probably helps that you're also like, are you a little more hands off with cases themselves and you have like associates that are really running the ground and you're just kind of upper level management?
Yeah. I don't personally do any cases in litigation. But like, if there's an issue, like, and people want to talk about it, I'm always I know what's going on. If there's like a settlement offer and we're trying to figure out what we want to do with it, or if there's a trial coming up, we'll kind of all get in. But like the day-to-day of the case, I'm not involved in at all.
Yeah. And is that difficult to take that step back?
No.
I appreciate the honesty.
No, that was what I wanted to do. So, we got to a point where we had all these files, and with the staffing that we have, it's too much to have the person who's kind of managing it also running like as files, because like, as you know, with litigation, like, all right, you got a dep. Well, for me to be out of like communication with the office for 3 or 4 hours while I'm in a dep, it just doesn't work, because there's too much going on. And so obviously we hired more staff and associates to handle that. And so I've been wanting to get out of the litigation part of it because it was taking too much time out of me growing the business.
Yeah. So one thing I'm curious about before we like dive into our real topic here, because I always want to pick, plaintiff's attorneys' brains on this, is clients and like your assessment of a client's case and, the good ones and the bad ones. Like, what goes into weighing in when you get a potential new client in, you hear what their facts are, what goes through your head is be like, is this a case we should take? Is this a case we shouldn't take?
Yeah. We have a lot of qualifiers. And I think claims people will be interested. Like most people that call us, we only probably take on less than 10% of the people that call us. And even that 10%, 20% of those cases get dropped before anything happens because for whatever reason. But when we first get a new case, we're looking at to make sure it's obviously something, the practice area that we focus on. The data accident is within a reasonable time, because if it's close to the statute or whatever, we're not going to want to get involved in that. Then we're looking at, liability and damages. Is there liability clear? Is it not so clear? Are the damages there? Or, to make up for the fact that liability may not be as clear, but if it's bad liability and not little damages, what are we doing? We're not gonna do that. But maybe if there's big damages and we think we can come up with something, then, we'll take a run at it. But it's mostly like, date, location, different counties, we're going to want different things.
Mm-hmm.
We practice in Pennsylvania and New Jersey, but a New Jersey case has different rules in Pennsylvania. And we may take a case in PA that we wouldn't take in New Jersey. But that it's date, location, damages, liability, those are the factors. But I think most people would think, like, when they talk to lawyers, like, oh, you guys take every case. I'm like, no, it's like out of 10% that we sign up, only 8 of those make it through. And if we file it, we're going to win. I think we lost 1 case last year.
Wow. Good for you.
That we filed.
Yeah.
So like, that's when, like, if we file something, it's already made its way through us so many levels that like, it's a winner. It's just a matter of how much, unless something happens, like they get a subsequent accident, or like turns out they lied to us, or like something that we didn't know about, but which happens.
Yeah.
By the time it gets through in the litigation, it's most likely a winner.
And that's interesting to hear, because that's a really low percentage.
Yeah.
Because on my side, I'm not saying for your firm, I don't even think I've had any cases with your firm, but like sometimes I have cases come across my desk that I'm like, why is this even in suit? Like, why? And why is the demand this much? And that goes to my next question that I'm curious about is what is your process with setting a demand?
Yeah, when I sit as JPTs, I run into demands from plaintiffs' lawyers that are just like astronomical, and I just don't get it. And it's not helping the process at all. We like to make demands that give us room to negotiate. One of the things that we do that maybe we don't give demands until we have a good faith offer. So until there's an offer that's been presented to us that our client could at some level conceivably take, we will not make a demand. And that's just the way we do things. But in our demands, we look at the treatment, we look at the damages, we look at the county, the economics, and we give ourselves room to negotiate. And depending on who we're dealing with, we can be a little bit more to the point. If I had a case with you, I'd be like, hey, I'm going to make this demand. This is where I think theoretically we could be if you can get me there, that I could probably sell the client on taking it. But we're working with.
And like from my shoes, I much prefer an interaction like that. Like I can't stand when everyone's trying to be super cagey and we have to like, oh, we're going to go up 5,000 and then you're going to come down 10. And then we're going to like, I'd rather have that upfront discussion and streamline the process versus having, 10 back and forth interactions that were really not moving the dial at all.
I 100% agree. Well, so in this, when we talked about what we're going to talk about on this, I was like, the biggest thing that I run into with claims adjusters that annoys me is that like they're too robotic, and they're like, well, I have to offer you 12.5 when I have 45. I'm like, okay, if you offer me 12.5 and the case is worth 45, we're probably never going to settle it because I'm just going to file a lawsuit because I think we're never going to get there. And then we file it, then you guys offer the 45 immediately after we file it, which it doesn't make sense to me either. Like, get to the point. Like, if you think the case is worth 45 and you have 45, offer me something that I conceivably can think that we're going to get there, because I'm not going to play the game 5,000 a time to get there.
Yeah.
For us, we settle the cases for what we think they're worth, not from what you're offering. So if you never get there, it's fine. I'm not insulted, but like, the claims process is to try to resolve cases. So you have to like put a little effort into it, not be as robotic, and you have to pick up the phone. That's another thing.
Yeah. That's what I was going to ask. So, and I think I'm generalizing, but I think at the outset, sometimes at the initial receipt of of claim, that some adjusters might be, they don't initially want to pick up the phone and call counsel, but I think it's for a variety of reasons. I think sometimes they have some counsel who are like rude to them. They have some counsel who like, I think the rude one is probably what happens the most. So they have, but I do think, actually talking to someone really gets you a lot further than exchanging emails. Let's face it, lawyers don't like to put anything in writing that we don't actually have to put in writing.
Yeah, I don't negotiate on email. Unless it's like I'm close and someone said, hey, let's say they offer 22 and I think it's worth 25. I'm like, you give me 25, we'll take it today. Like something like that. But doesn't help the settlement. A 5-minute phone conversation can get the case done if the adjuster has the authority to do it, and is reasonable. But a lot of like Progressive, for instance, it's not even worth talking with them. They are just so robotic, and they'll start every case at $1,500. I'm like, well, if my case is worth $200,000 and you offer me $1,500, like you're going to get hung up on. Like there's no point in my wasting any more energy on it. Like, so we don't even attempt to settle cases with them anymore. It's completely pointless. But on the other hand, some of them are really easy to deal with.
Yeah. And that was something I was going to ask later, but I'll jump into it now because I'll forget. When you have a claim and then you find out, who or what entity the insurer is, do you have sometimes an immediate reaction like you just had with Progressive, like, I'm not going to get anywhere with this, or I've never dealt with them before, so maybe this will be better?
Yeah, I mean, here's what I tell clients too. Other than Progressive and maybe Liberty Mutual, I tell the same thing to clients when I sign them up. They're like, what's my case going to settle for? How much is it going to settle for? One, I can never tell you that because I have no idea what your case is worth until later on. But once we get closer to when we send the demand pack out, I'm like, you could have 2 adjusters from the same company sitting right next to each other. One may pick up the phone all the time and be reasonable. The one next to them, you may never get a hold of. And when they get a hold of them, they offer you something that you could never accept. So it's hard for me to predict outside of Progressive and Liberty Mutual that have like the plan not to settle cases. But yeah, I mean, a random insurance company are usually easier to deal with because they have smaller claims units, and the claims personnel is more sophisticated, maybe. Yeah. And they can, sorry. I got to turn my phone off. So the claims.
That's why you can't leave the office and you can't take depositions.
I know. Well, I thought I turned my phone off. Someone's like blowing me up here. But so like a person, and you probably see this, is like some of the claims people maybe have more experience or they have more authority within their insurance company to make decisions. And those people I can settle a case with in 10 minutes, and 9 of them are talking about something unrelated to the case because they get it and they can and we're reasonable and we get the case done.
Let's just back up. So if you could give us some advice to say you have a newer claims adjuster who's getting a claim with you or some other office for the first time, what would be your first step of advice of how they could get that? Because let's face it, all claims adjusters, or most claims, you want them to be closed. That you don't want a lingering claim. So what advice would you give from step one to be like, this is the best way when you get this to start off on the right foot, and we can move this in a reasonable direction, so we get it done for a good number, not just a number that works for you, but a number that's good for all.
Of course, and that's the only way the case is going to settle if everybody's happy with, because
Yeah.
the claims aren't going to offer something that they're not ultimately happy with. So from initial opening of a claim, I would say they don't have to do anything. Just respond, send us a letter or an email with your information, your email, your phone number, and that's it. Because at the initial part of the case, we don't know what we have yet, because typically we get a case and maybe they have been treated, or they're just starting treating, so we don't really know. It's really when we're interested with the claims professional is after we send the demand pack, the first thing would be like acknowledging that you received it. Like, because half the time we send them out and like, oh, we never got it. I'm like, well, we emailed it to you, like it didn't bounce back. Like, why didn't you get it? This is the email that you told us worked for you. And like, hey, if the adjuster switches the file, maybe like letting us know would be helpful, and picking up the phone so we can confirm that that's the adjuster on the file, confirm the email or the address wherever we're sending. That's like, believe it or not, like 50% of the battle of getting a case settled is getting the demand pack to the adjuster.
Yeah.
They just aren't available. After that, what we do is we give the adjusters like 30 days to look over the demand pack, which we think is a reasonable amount of time to make a decision on the case. If you hear back earlier, let us know. And if you don't and you need more time, like try to be reasonable with this, because we have clients that are asking us what's going on with their files too. Once we get to this settlement, it's like, all right, like you've looked at it, you're prepared to like make an offer, or you're prepared to say you're not going to make an offer, which is okay too. We just want to know. That's kind of the thing. So like, be prepared to answer them, be available by phone. Once the offers are kind of coming, I always say, like, once we get an offer and it's kind of in the realm where I think we can settle it, like we could probably get it settled that day if you're available. Because I could probably get the client available and be like, all right, just pick up the phone and we'll bounce back and forth a couple of times and get it done.
Yeah.
That's availability and responsiveness is probably like number one complaint with adjusters.
Yeah. Yeah. And I do think a part of the factor is too, I mean, like just like you or your associates, they have a lot on their plate too, and they have a lot of claims to run through on a daily basis.
Yeah. I mean, I think that's why we give the 30 days, which I think is reasonable.
Yeah.
And then also, like, I'm not offended by someone saying they're not going to pay. Like, if you're going to deny a claim, just deny it. Deny it from the get-go. Like, I'm not offended by that. Like, people have different views on how the case is going to go, and that's why there's court. But just let us know, because then we'll like just file it and not waste our time sending a demand pack, or let the clients kind of get their expectations in line.
Yeah. And I mean, client expectations has to be such a huge part of what you do behind the scenes, because you could try to manage your client's expectations, but that doesn't mean your client isn't going to have unreasonable expectations. So, how do you work on your end to try to get your client or your clients to be in our stratosphere of reasonable expectations?
Yeah, that's a tough one. I would say most of the clients come into it and be like, you're the expert. You're the person who sees this claim all the time. We're going to respect that you're looking out for our best interests and your opinion on the case. Because ultimately, the way plaintiffs' cases work is the more money they get, the more money I get. So whenever we're trying to get expectations, like, listen, if I could get you $10 million on your case, I would love to do it. But unfortunately, it's only worth 30 grand. So this is what we're working with. And then you kind of run the pros and cons. Like, hey, you can take this money. Depending on where we are with the case, like you won't have to pay the $5,000 to do the doctor's debt. You won't have to go to trial and spend a week doing trial and costing us another $1,000 for the playback, and especially on a smaller case.
Yeah.
And then there's no risk. So are you the person that goes to the casino and bets it all on black? Or are you the person that says, no, I want to take my money and go home? And once we get to the point that we've kind of said, like, listen, this is the number that is in the realm of reasonable, you start having that conversation. And then some clients appreciate it and respect it, and some they want more than they think it's worth, but we don't really run into that problem too much. It's usually just getting the money is from the clients usually kind of listen.
That's what I was going to ask. Because I've been in situations that I've talked to counsel and they've discussed to me like, look, I'm recommending this number that you have, but my client is not taking it. So
it certainly happens. It's infrequent, but it happens. We usually just work our way through it. Like it's usually time and maybe like, it's usually like a case where like, if it goes to trial, there's like a risk of losing. Like if it's a rear end car accident, they're full tort, like that case settles because they get to a number. If it's a slip and fall and maybe there's a liability dispute, I'm like, listen, like you could lose this case very easily. Or you could say like, if the case is worth 100, but they ding you for 20% of contrib, then you're only getting 80 plus the 10 grand we got to do to try the case. Now you're like, where are we? Like,
yeah,
you kind of work it down. But that also goes back to us. Like we wouldn't recommend the number until it was a number that like made sense in light of all the factors that could go against it.
Yeah. I mean, let's face it, like any side, if you're going to trial, the costs that you have to have real discussions about costs, because suddenly now you're paying experts to be there. You're paying your time to be there, your prep to be there. I mean, it just gets expensive on both sides, albeit sometimes necessary though. I mean, sometimes you have to go to trial. I mean, you're just not going to meet in the middle.
Yeah. I mean, I always think on your end, it's probably like a cost is maybe a different conversation, because for our end, obviously the clients don't pay us like hourly rates. They just pay like the expert, if we lose or if we win, that comes out of the settlement. But for like you try a case, you're there for a week plus prep, that could come into a big bill, plus the experts, plus they could lose. And depending on what type of case it is, may expose to like some bad faith, some excess stuff going on. There's a little bit more to factor in on that.
Yes.
On our end.
Yeah. So one thing I wanted to move to is, okay, so you get to the point that you filed suit. What type of responses to complaints are worthwhile for defense counsel to put the time and energy in, and what types of responses do you find like are not worthwhile? Like for instance, like preliminary objections, like I think sometimes are worthwhile, but other times it's just, why are you filing preliminary objections?
Yeah, I agree. I think that if it's a rear end car accident, and just answer the complaint. Like you don't have to call, just answer it. And I would answer it within 20 days because we're going to file a 10-day and we're going to take a default. If it's something where you want a PO, I was like, hey, call. We probably agree to it, because our complaints, we kind of veer everything and then leave it up to, the facts to come out. Some of the stuff we might agree to take out without prejudice. Some of the stuff we may agree to just to take out. I don't know. If you got a call to find out, it's definitely worth calling rather than file POs, because you're not really doing your insured a service by wasting time on something we probably could agree on.
Yeah.
I think if the party's spelled wrong, let us know so we can just amend it, or agree to stip the change. But other than that, it's just, if it's something simple, we could probably agree to it. If it's something more fact specific, you probably have to PO that, but it's definitely worth a phone call.
Yeah. I mean, I've always erred on calling about POs, but then sometimes not for nothing, there are some counsel out there that are real jerks about it. And they're like, nope, not going to take that out. It's like, all right, I guess we're going to have to go through this exercise and see what happens. I mean,
that's kind of the same deal. If there's something reasonable that you think is not relevant to the case that you want to call, we'll probably agree to take it out, because we have a standard form that we file for every complaint. And maybe there's something in there that a rule violation, but there wasn't a rule violation. So you want to step that out. Okay, fine. Unless we have one that we cited specifically, okay, you could take that out. But filing POs is just a waste of time, because we'll just file an amended complaint and take it out, and then you just wasted your time filing the POs. It's stupid.
Yeah, it's so dumb. It drives me crazy. And there's some things on POs that I'm like, okay, I wouldn't PO on this on its own, but if I'm filing POs on this other issue, then I sometimes tack on something else that I probably would have called about, but the other issue is not something that you would say there's an arbitration agreement or something I'm not going to call you and you're probably not going to agree. So I'm going to have to file something on that. But, other issues sometimes can just be fixed.
Yeah. I mean, we were, in terms of like just streamlining like the litigation, but we were one of our associates was just about to go to trial last week. And I was like, listen, before you go in there, try to work everything you can out, like call the attorney, like make a phone call, like agree to the verdict sheet, agree to the point of charge, agree to all this stuff. So then when you show up, it's done. And the same thing kind of goes with the pleadings. Like the more you can just streamline and get to like,
yes,
hey, these are the facts of the accident. These are the damages claimed. Like, let's just focus on those two things. The quicker you'll get the claim resolved. Because what we're finding is that we're defaulting so many people or getting them precluded from testifying that like, they're not even getting to that because we're just knocking people out early in the case.
Yeah.
Who aren't responsive.
And, I don't see that a lot. So that's that's a pretty aggressive approach that you're taking. That I mean, I really haven't seen much of it as of recent. So it's working for you.
Yeah. I mean, again, we do it because it's automated and it's just easier for us to keep track of. But yeah, we do get people precluded and we do take defaults. But like they deserve it because there's plenty of opportunity to like file the answer. And we even send the 10-day letter to the adjusters. And if they don't respond, then like, don't know what to tell you. Like we got double policy limits on a case not too long ago.
Wow. Good.
Because I sent the 10-day notice 10 times to the adjuster. She never responded.
So, okay, if we're going to, other than, adjusters like responding to you, and picking up the phone and talking to you, what other tactics do you see that you find aren't moving the ball forward, aren't moving you anywhere towards resolving or just putting a bad taste in your mouth that, you're like, forget them. I'm just not going to deal with them anymore.
Yeah. So the big thing is like telling me about my case. The adjuster calls and says like, all right, so like he had a prior. I'm like, okay, like, is it relevant? Did you run the ice? Like, did you get the reports? Like, no. I'm like, okay, so why are you telling me about it? Like, don't tell me about the case. Like we're come to the point where like, we're trying to get the case resolved. It's a numbers game only. You're not going to talk me out of taking the case. You're not going to talk me out of like filing a lawsuit. Either you're willing to settle or you won't. So like, let's get to that. That annoys me. But that's again, going back to like that adjuster who is so robotic that they're just following the list of things they have to do. Like just talk like a human. Like we can be normal. If you don't want to pay, that's fine. I can accept that too. But if you are, let's just do it. If you're not, let's just do it. Just tell me no.
Yeah. What about like motion practice, like summary judgment motions? Are they like the bane of your existence when one comes across?
Yeah, I mean, for the most part, they're fairly similar, the ones we get. It's like usually a premises case, usually on notice or something on that. We did have one that was a little off, but they're not so bad. I don't do them anymore either, so it's...
You don't care.
So, but it does slow down the process because you don't do a lot of writing in litigation. There's not like a ton of writing. So the big writing comes up in summary judgment. So I tell the young guys and gals, I'm like, I can't wait for you to get a summary judgment motion because now you're going to be an expert on that. Whatever that case is about, once you write the summary judgment motion, you're now an expert on that, like Hills and Ridges doctrine or whatever it is.
Yeah.
So they're okay. I mean, I get it why people file it, and it's fine. It's just another thing to do.
Yeah, I had one an argument on one the other week, and I was talking to plaintiff's counsel ahead of time, and he was like, "Oh, you had to make me. I hate writing so much." And then I had to, and he's like, and there was two defendants, and we both filed summary. He's like, "No, I had to respond to both of you. Like, what a pain in my butt." I'm like, sorry, like I told you it was coming. Like, I mean, I flat out told him, like, look, we will be filing a summary judgment motion on this case. Like, it's just I have to do it. Right. And he understood it. And that was the other thing that I'm curious how you feel about this. Cause I had a conversation with this attorney up front. I was like, look, I'm looking at this as a summary judgment case. What other discovery are you going to do? Because I just want to know ahead of time so I don't file this summary judgment motion and then you respond like, oh, wait, we're not done with discovery. He's like, oh, I appreciate that. I'm going to get this expert and I want this other dep and then I'll be done. Do you appreciate that type of interact? Even I know you're not responding to these motions anymore, but I feel like that streamlines it and cuts out a lot of the BS. Like,
yeah. It also may knock out the reason for even filing it. Like if there's
Yes.
another discovery comes in and you're like, all right, well, I wasted all this time filing summary judgment, but then they took a dep and then now notice is out, like whatever. Yeah, I think that's smart. I don't think that anyone's ever done that with me. So,
Really?
but like we don't get a ton of summary judgment motions. Like it's not that plentiful, and you can kind of anticipate what cases they're coming on. But like some of them are like a waiver on like a amusement park case. They're gonna file like a summary judgment on that, but we have that response. So it's just like, oh yeah, the waiver response. Okay, yeah, that's the one we use 10 other times. So we'll basically just kind of tailor it to that. But I think that's a good move. I mean, definitely call for sure.
Yeah. Yeah. And I mean, it was in this particular instance, it's one of those like, I know it's 100% going to happen. I can't walk and I always take venue into account. If I'm in a certain venues, I'm not going to file a summary judgment motion, regardless how strong I think it is, because once any opposition is filed, I know it's going to get denied, like sight unseen. So,
but, on your end, maybe they don't file a response. I bet that happens.
It does happen sometimes.
Yeah, and that's a shame. But yeah, I mean, in Philly, you're filing a summary judgment motion is not as advantageous as doing it in Bucks County. So you gotta, I get it. I mean, I get it why people file them. We're not offended by it. You got to do your job just like we got to do ours. So you file it. We get it.
Yeah. How do you view them though as a leveraging tool for settlement?
Yeah, it's smart. I mean, that happens. Those are the cases that happen. They file it right before the JPT conference, or like discovery ends, file a JPT conference scheduled, but the summary judgment motion hasn't been ruled upon. Depending on the strength of the liability, it can almost be helpful for us at some level with dealing with our client. Because if our client has like those outsized expectations, we're like, well, there's this motion coming, we don't know what's going to happen with it, and you may want to take a discount on what you think the case is worth, because if you get blown out on summary judgment, like it's over.
Yeah.
So I think it's smart on the claims end. Like if you've got a reasonable chance of winning, then I would do it. Now, that being said, we have seen some nonsense summary judgment motions wherein we file a response asking for sanctions because it's just a joke. we ask for a lot of sanctions around here.
And I imagine in Philly you might be more successful than other venues.
Yeah, I think Philly just is like a wild west, like courts. It's just kind of anything goes, and people file like nonsense. Like this one case, I've never heard of the things they're filing. Like they're creating like new recipes and motions and stuff. I'm like, it's like not a motion for reconsideration. It's like a motion to like reconsideration or something. Like something.
Yes.
Like you lost, dude. It's like twice. Like it's over. Like.
Yeah, sometimes it's hard to take. Sometimes it's hard to take that denial though, all the way home.
It's like for a dep, like it's not even like it's not in contest. Like we're getting it.
Yeah. Well, one thing I'm curious though that reminds me of is in like discovery court in Philly. When you talk about Wild Wild West, I think there's no other place that's more Wild Wild West than discovery court in Philly, because you can have, at least in my eyes, I can have a very valid point on a motion, and then you get up there and argument before whatever judge, and the judge just does whatever they want.
Yeah.
Which I guess that's what judges can do, but it's almost like, why are we going through the motions of filing these motions when really the outcome is completely arbitrary and we have no idea what's really going to happen?
Yeah, I mean, we have the same issues. So our biggest thing will happen, like we'll file a motion for whatever, discovery compel, granted, sanctions granted, then we get the preclusion and we don't get that order. So like we'll file 6 motions to get, and we still have discovery. I'm like, all right, well, at some level, at some point we have to get them precluded because there's no penalty for them. And there needs to be some sort of repercussions for them not participating in what the courts deem they have to do pursuant to the rules of civil procedure. Yeah. So, sometimes we get it done on the first motion. Sometimes it takes 6 or 7 motions to get that preclusion order entered. And that to me is not right. Like if they haven't been able to do it in like 3 motions, and they're never going to do it. And why should we have to keep trying? And same on your end. If like you guys are filing motion and the client's not participating, like knock them out. Like they clearly don't want to do their case anymore.
Yeah. I mean, I have had that happen a few times, that when plaintiff's counsel is just like doing nothing on their case, and then I forget what the motion is called. It's like a
Non-
failure to or failure to litigate too happens if they like in other counties, they don't have the short discovery deadlines like Philly that you can just try to kick it out that way. But sometimes it wakes them up too. They're like, oh wait, I have this file over here. I need to do something on it.
Yeah, I mean, that's really a disservice to the clients, and that's what we try to avoid doing. But yeah, I mean, listen, a lot of the stuff in our conversation today is just being responsive. If you're responsive in this industry, like you're gonna accomplish what you're trying to accomplish. I mean, that's answering discovery, and most of discovery court is just failure to act. It's not like we don't agree that we should do it. It's you just haven't done it. That's what we run into. We're like, listen, we want the discovery, we're entitled to it, and maybe they can't find their insured. That's not our problem. Like, you're a $1 billion insurance company. Go hire someone to find them. I don't know what to tell you.
Yeah.
If our guys if we can't find our guys, we'll withdraw from the case, because how are we going to take the case to trial if our guy doesn't show up? It's precluded, so we're done.
So in your eyes, though, if you have a case and you have multiple defendants, is that more of a headache, or is that helpful from a resolution standpoint, or a little bit of both?
Yeah, probably a little both. Depending on like who's really at fault, and this goes back to the kind of the cost. Like, hey, if there's 5 defendants on like a premises case, and one guy's kind of the big player, but the other ones are kind of involved, but they all have lawyers. If we try the case, they're all paying the same amount of fees for prepping for trial. So depending on the value of the case, you may be able to get the case resolved because there's more pockets to go after. But then you have 5 summary judgments to respond to, and 5 deps, and 5 whatever to respond to. But
or all these entities at depths. Like, sometimes that can be like the world's worst nightmare when you have so many extra people in the room. But what are some things that you've seen that you've seen from either defense counsel or an adjuster do that like you're like, oh, that was a really, really smart move, or that, that was something surprising I haven't seen before and it worked?
I don't know.
You're going to give people ideas now too.
No, I know. I mean, I think I can't think of one specific thing. I'm like, oh, that's crazy. I can't believe they did that. But like the big thing with to me that I would give to claims adjusters is that like, if you offer what you think the case is worth, but offer like a little bit less, get us right to the point where like, it's just stupid for us to keep going. Because if you're going to pay it later on, just get it done now and save yourself the cost.
Yeah.
Because that's when the clients will take them. Like, if the case is worth 50, but you offer 45, I'm like, or 42, I'm like, all right, well, like, you're not really making that much more money for holding out for another year to hope to get $8 more grand. Right. Whereas if you're the claims adjuster, you just saved $8 grand in settlement plus the legal fees in doing it. Yeah.
And, on your side, do you find there is like, this happens a lot and you probably know this, but when towards the end of the year, adjusters and counsel talk like, oh, well, it's the end of the year. We want to get this, maybe we could try to get this done for a discount before the holidays. Is that a real thing? Like, does that really work?
No, I don't think, I don't think it's ever a discount. I think maybe at some point you find that adjusters are more available, but I also think it's probably because they take 2 weeks off for the holidays and like have to work a little harder to get the cases done. Maybe, I don't know.
Yeah.
There's no discount. There's no time discount.
It always comes up either when you're talking to other counsel or, you're talking to certain adjusters. They're like, oh, well, Christmas is coming up. So wouldn't it be nice if, maybe if we try to get this done before Christmas, they'll be more inclined to settle it now and have money for the holidays.
I mean, again, that kind of goes back to what I was saying. Like, if you offer a number that's kind of close to where we think it should be, and we're like, okay, like you're going to get it now as opposed to waiting another year, then yeah, they may take it, but it has to be in a realm for, at least for us, where we think it's like not unreasonable to take it. If the case is worth 50 and you offer 20, well, we're not going to take it. If you offer 40, I'm like, okay, like, is it worth you hanging out for another year to make an extra however much minus our cost and fees? I don't know. You may want the money now, but that's the adjusters that are most effective with us, get you to that point.
And now I'm thinking back on your comment that you don't give demands until you have an offer.
Good faith offer.
So what is your reasoning behind that?
A couple things. One, I don't want to waste my time, like
Mhm.
dealing with something that's never going to settle. I'm not trying to help the adjuster document their file for something that isn't going to help our case settle. And I don't want to pin myself down to something that may change later on. Now, when I mean good faith offer, I'll give you an example of a bad faith offer. The client has 10 grand in bills and they offer 5 grand.
Sure.
Okay. So the client has to pay me, we have costs, and they have to pay their medical bills. They're never signing that. So
Yeah.
that's not an offer yet. It's not an offer until it's something they could potentially make money on, to get money on. Like paying us in the doctor's bills or getting their lost wages back that's not a settlement. So like, that's what I mean by that.
Yeah. Because I'm my side, I feel it's equally as frustrating if you have a case that, say it's like, I don't know, a rotator cuff tear with surgery, and the initial demand is like 800,000. And you're like, okay, well, like where you get, do you have $200,000 of bills to put on the table? Like
Maybe.
those, yeah, sure. Of course it can happen.
Yeah.
But from my eyes, I'm like, well, it's equally as much as a non-starter, because, if you're already all the way up there, like, how do I even, like, especially if it's pre-suit, like, how do we even respond to that pre-suit when you start off so high?
I would just not respond if I were an insurance company. But I mean, we don't give demands in our demands. We just send the records and we wait to hear back. But I mean, I think from your point early on is like, if you get that case in litigation and the claim adjuster forwards that demand to you, oh, they demanded 800 grand in prelim. I'm like, why don't you call us and be like, hey, you guys demanded 800. I kind of see the case hypothetically, in whatever range you think it is. Is that something you think you can get to? Like, not holding you to it. Like, and if you can, maybe we can get rid of it. I don't know. But
yeah. I mean, I think a lot of it boils down to having those types of conversations and not being afraid to have those conversations. And I think attorneys and adjusters sometimes are hesitant because, like, well, what if I say this and then I'm going to get held to it later? In reality, we're all trying to like get a feel for where you are without saying, yes, 100%, I will do that.
Right. And I always say the hypothetical, and I always offer that to the adjusters. I'm like, listen, I'm not going to hold you to it. What's your hypothetical best offer so I can even see if I can get this done? And then I'm not going to hold you to it. And if she doesn't, if we can't get it solved or settled, then forget it. Yeah. But that's a good way for me, at least that I've found, to like, let's just get there. Hypothetically, I think the case is worth 200. Okay, let me talk to my client. Okay, hypothetically, we could take 200. You would say, all right, let me go get 200. I'm like, okay, we're settled at 200. Like
yes. Yeah.
But you can do it without like holding yourself to it. And listen, demands are subject to change. Things can happen during the course of the case. Maybe they had a subsequent surgery, or we got a wage or a life care plan or economist, and that boosted that $200,000 case up to $500,000.
Yeah. So I'm glad you mentioned the experts, because that was one of the things I want to talk to you about, because, expert retention is such I don't know, it's a thing. So like, I know it depends on what cases you have, depending on how you decide what experts you retain. But for you, it is money to put out up front. So you really have to have a reason to bring on that expert if you want to pay their fees. So, walk me through like your thought process on like, okay, do we need a life care plan on this one? Do we need to spend the X amount it is to retain that individual for this case, or can we go without it?
Yeah. So, I mean, it depends on like the quality of the case. So if the liability is good and the damages justify someone needing a life care plan, then we'll have to look at whether the policy limits of the insured are there to justify the cost. So if it's a $15,000 case, we can't spend $3,000 on a life care plan to get 50, it's just wouldn't make any sense. Now, if it's a premises case or a case against like a commercial trucking, and we know there's coverage and the damages justify having the report, which is the main thing. Like if the injuries aren't there and they don't need any more treatment, then there's no point in getting a life care plan. But if the person like has a herniation or whatever, and they had surgery and they may need further injections or whatever, and there's the policy in place to justify the cost at the end, then that's when we would do it. But you're really looking to see if all those things kind of have to add up. So
yeah. because I've had so many scenarios that it's not a great case. And then I get all these expert reports and I'm like, why are they spending all this money on these experts? Are they doing it just to boost the bottom line? And sometimes I feel like that is the case. Like let's line up these 6 experts. So I can set like I've my bottom line is now here because I have this person saying this and this person saying that.
Yeah, I mean, I guess that's a strategy. That's not one that we like to do because it just, to me, logically doesn't make sense. If the injuries don't justify it, then you got the life care plan. You just look kind of like a fool. Like no one's going to believe that the person needs that if they don't believe the underlying injury needs that. So
Yeah.
for us, I mean, we will do it when we think it's right. I would do it on every case if it meant that it was the right thing for every case, but it's just not. And
No.
getting an expert just to get an expert, it just costs you money. I don't think it helps.
Yeah. I mean, I even think about it on the defense side. Like sometimes just because, the plaintiff might retain this expert doesn't mean we need to automatically get a rebuttal expert for that expert. Like
No.
sometimes it's not necessary.
Well, that's the thing I run into with defense. Like, let's say it's a broken leg from a car accident and they had surgery like at the emergency room from the accident. Do you really need a report to say that the surgery is related? Of course it's related. Like, why spend the money on it? Like,
Yeah.
it's related. Yeah, maybe you get a report to say that like he's fine, but like, why even have someone comment on it? Like, I don't get it.
Right. And I agree with that too. Like it's like but that's also a check the boxes approach that I think some, defense counsel have too. Like, okay, well, they got an expert, so then I need to get an expert. Well, not necessarily. Like you have to look at the whole picture and, are we contesting causation? If we're not contesting causation and say this plaintiff said they're feeling great and they can, basically resume their normal activities, then maybe we don't need to spend, $1,200 on an expert to say that they've resumed their normal activities. Like I
mean, if you have a plaintiff that resumed their normal activities and they said that in the depth, getting an expert, unless you're challenging causation, is 100% a waste of time because all you're doing is giving me now 2 doctors that say the accident's related to the accident. So it's
right. Like helping you out.
Yeah, it doesn't make sense, which happens a lot. And I think it is that checking the boxes, like we have to do this. And I don't know if that's coming from the lawyer or from the adjuster, depending on maybe the company making that decision. But we see that too a lot. Like you don't need it.
No. And sometimes I think that comes from on a defense side, inexperience, or also just not being taught to, like, you don't have to run down the sheet and do all the things on the sheet just because there's things on the sheet to do. Like, sometimes you might not need to even take the plaintiff step. Maybe you could just, again, pick up the phone and talk to you and be like, okay, like maybe we can get this done without anything more.
Yeah. I think in most, I don't know, like if the case is like a clear-cut liability case and you're just going on damages and you don't have like a limited tort argument to make, like there's no harm in like reaching out like, hey, like I got your medical records. Like, is this one we can get rid of? Like, I think the case is worth 50 grand. What do you think? Hypothetically, like, okay, like, are we on the same page? Assuming you have the money. But I think you're right, is that people don't think they're going to get in trouble if they get an IME or DME, we call it, defense medical exam.
Mm-hmm.
But so if they get it, they won't get in trouble. If they don't get it and the trial goes bad, like, oh, you didn't get a defense medical exam. It may have nothing to do with it, but
right.
At least they can say like that they got it. They did everything they were supposed to do.
It's called the CYA approach.
Correct. Which isn't necessarily bad. Which isn't like, it's not a horrible thing to say, because I may say a trial that you could have gotten a doctor to say that my client wasn't hurt and you didn't do it. So
yeah.
because you think that my client was hurt.
Yeah, of course you're going to say that.
But yeah, I mean, you just have to have kind of the guts and the confidence to make the decision on a case-by-case basis, as opposed to just like every case needs this, every case needs that. Like it just doesn't. Like, especially if you're trying to resolve claims.
So how does the credibility of your clients, as well as the credibility of like the defendants, like how does that sway your evaluation?
Yeah, that's huge. I think a nice client is better served than a really hurt client. The nice client's going to do better than the really hurt client that's a jerk. Even on like the intake stage in our office, our intake team, I'll ask them, I'm like, is the person a nice person? Because if the case isn't like that, if it sounds a little funky and the person's really nice, okay, now we can work with that, because later on they're going to be likable and credible, and we're going to be able to work with them. If they're a jerk already on the phone with us day one, they're not for us. So I think goes both ways. Like if a defendant's really nice and really credible and like they just tell the truth and they're straightforward, then the jury's not going to want to punish them. But if they're evasive and they're a jerk and I can make them more of a jerk, then that's better for us, obviously. But yeah, I mean, our client's credibility and likability is as important as damages at trial.
Yeah, I will say I had a trial many years ago against your old firm, and my client came off so less than credible. And it was an arbitration appeal. So I mean, already like this case was not worth a ton, and this person was so bad, like it was terrible. I got smacked. I think I was like 8.5 months pregnant too, and I came back crying from my office. Like it was the worst. And I truly believe it was the plaintiff was very credible and came off like a very nice individual, and my client came off as a very dishonest, like no good record keeping. Like it was just terrible, and I think the jury just did not like my client and thought they were a liar and just smacked it.
Yeah, I mean, I think it's a huge factor in it. You know, the more likable our client is, the more disliked the defendant is, the easier it is for them to get their heads around giving our client money.
Yeah.
But it's a big factor, and anything that we can do to make defendants look horrible, we're willing to do. So.
Yeah. Of course, the big bad company or the big bad, individual, whatever it could be.
Listen, these companies don't do themselves any favors. They're so poorly run. They're just asking for it half the time. I don't feel bad for them. Like I had one guy in a slip and fall case in an apartment complex, and like they didn't get to like my client's area and she slipped and fell and she like fractured her knee or something. And she's like, "Oh, our complex is so big we can't get to it." I'm like, "Hold on. So you saying that your complex is so big because you have so many units and you're getting rent on so many units that you can't afford to pay for like the proper cleaning service?" How do you think that case went? Like, what an answer.
Yeah, that was a good one for you.
That one did not try.
But have you ever had a scenario that you're at a deposition with your own client and your client says something asinine that you're like, shit, like that just totally changed the course of this. How do I recover?
Yeah, I mean, we try to like correct it in depth, but like, for instance, on like a case where like a slip and fall, these are like the harder depths. What'd you fall on? I don't remember. What do you mean you don't remember? You just told me you fell on this for the last 2 hours. Now you don't remember when you're in the room. If you don't remember, your case is over. So like that kind of stuff, or like being evasive for no reason. I think from our clients, like, we give them instructions, like, if you don't know the answer, tell them you don't know. If you don't remember, tell them you don't remember. But like within reason, like I guess that's kind of the slip and fall one. But I will nitpick you a little bit on defense. Why do people always ask what kind of shoes our clients are wearing? Like, what does that matter? Like last time I checked, I've never been to a store that said like it just says you have to wear shoes. It doesn't tell you what kind of shoes.
Well,
and who remembers what shoes they wore 2 years ago?
A lot of people, a lot of them save them. Like I've had plaintiffs, they come with the shoes that they were wearing, but I think a lot of that runs out of, if it's a snowy day and they're wearing like flip flops, or if it's a rainy day, like shoes that don't have any sort of tread on them, and the shoes aren't appropriate for the weather conditions. So it goes with what a reasonable person might do.
I guess there's such a dumb like who remembers? I don't remember what shoes I wore yesterday, let alone like 2 years ago. Like, come on.
I mean, I wouldn't probably remember, but maybe you would if you were in an accident and you fall and it's that traumatic. You're probably going to remember the shoes that you were wearing. And the best part is sometimes the accident report will say what type of shoes, and then they say something different, and now you have a credibility issue.
Yeah, if they made a report.
Yeah, well.
Which is like half the time or less. I don't know. It's always a funky issue with those.
Well, but that is something that comes up on my end a lot, though. You have, I see a lot of plaintiffs who don't report the accident. Like they say they fall outside the store and they don't go in and tell anybody. And to me, that's a red flag.
Yeah, it's a red flag for us. I mean, if you've got like an unreported accident, like that, let's correct. If they went to the emergency room right from there, I'm like, okay, they went to the emergency room, like they didn't go report it because they were in so much pain. They just wanted to get to the medical provider.
Sure.
But like, they don't report it. And then a week later they go to the emergency room. I'm like, okay, like you're setting yourself up for issues already. And I'm believing them, but they're setting themselves up for like the first argument defendant said didn't happen, which is step one, it never happened or didn't happen the way you said it did. And if it did, you're not hurt. So like you're giving them out already in the case, which isn't great.
Yeah. I mean, obviously I think from your view, your best case scenario is probably someone witnessing the accident, EMS coming to the scene right away, and them going to the hospital. But very rarely does all those things come together at the same time.
Yeah, I mean, listen, like exactly. We're trying to eliminate the defense arguments, like, and that's what a lot of them are. It didn't happen, or it didn't happen the way you said it did, or you weren't hurt. So, like, if it happened, and we have everybody confirming that it happened, okay, and it's on the report, it's on the video, there's a witness. That witness their information's on the report. We deposed them, they agreed, and then not only they agreed that it happened, they saw the liquid on the floor. Everyone saw it. Everyone commented on it. All right. Well, now that kind of argument is done. It happened. Now you're arguing about, whether she should have seen it or whether you guys enough time to clean it up.
Yeah.
But the more information at the beginning that our clients provide the negligent party, the better, because it just starts the credibility of it actually happening, which is a big argument that you guys make.
Yeah. I mean, sometimes especially if you don't have anyone reporting the accident, it's such a, I don't know, from my eyes, it's such a problem. Like if no one knew about this and, you don't have any record of it, then that's an issue for me.
Yeah. I mean, sometimes people fall and they're embarrassed and like, they don't feel anything right away. Cause it's just like, let me just get up and like get going. And then like later on they start feeling it. Well, they already left the store and what are they going to drive back and make a report? I mean, I guess they could, but like, they're not thinking about their case. They're not thinking about like you asking that question later on, like you never reported the incident. And then like, no, I didn't because I wasn't feeling anything right away. Okay.
Yeah.
It's reasonable. But I agree with you that the report being there is better.
Yeah. So how do you take in your shoes? I'm sure you have some counsel that they take a no stone unturned approach. Is that effective in it for you to be like, oh God, like this attorney is not going to give up. They're going to do every single possible thing under the sun, or does this not matter?
No, we're the worst. So I think that we fight fire with like fire and like cannons and bombs. And so like, if someone gets really aggressive with us, then like that just puts my antenna up to like be on alert that we're going to like hammer this person. And then I'll just tell them that we're never going to settle the case and we'll just try it. We wish you the best of luck.
Yeah.
But like, that's not an effective strategy with us because we're also on top of our files too. So it's not like you're going to ding us on something. Like we're going to get you before you get us.
Yeah.
And no, that does not work with us. The most effective lawyers are like someone like you who's like reasonable, does their job, and is like a normal human that can like move the case. And you're doing your best to defend your client. And we're doing our best to put on our case. But like at the end, you're not doing anything shady. You're not doing anything like overly like aggressive at a depth that's like where I have to like get up and yell at somebody. It's like you ask the questions and like you do your job. Okay, we can all respect that. I think that people that do the other way are gonna set themselves up to get burned.
Yeah. I mean, I've always found or whenever I get in scenarios that I'm up against someone who is just a total jackass, like you tend to go into jerk mode too. Yeah. But I still always, I'm like, I'll always be cordial, but I just won't be as nice, if that makes any sense, because I don't need to be mistreated by you, or you don't need to be like an asshole to me. But don't underestimate me either, and I find that happens quite a bit.
Yeah, I think, listen, we're always polite and always nice until someone isn't to us in a way. But again, the most effective lawyers with us are the people that do their job, subpoena all the records that you think are reasonable, and you find that needle in the haystack that says my client injured their neck 2 weeks before the accident. Like, that's the most effective lawyer. But like, assuming that didn't happen, the most effective lawyer is the one who's reasonable, nice, and like gets it. Yeah. And just like, okay, you filed it. You're it seems like a winner. Like, how much can I knock off what you think it's worth and get it resolved as quickly as possible?
Yeah. I mean, let's face it, we all know each other's arguments. Like, we all know, like, I know what you're going to say.
They're literally the same, like 10 arguments every case.
Well, so we're just about out of time, but is there any other, nuggets of advice that you would give to an adjuster or defense counsel, to like effectively handle a new claim or a case in order to kind of get it done for the best number for them?
Yeah, I think I've said this over the time. It's just responsiveness. Like, the quicker you can get back to us, because think about, time is money. The longer the client has to wait, like, they're just going to get like it's not actually making it better, because I'll just like talk them into like, this is going to be a long process. But if you can get to it fast from us, and I can say that, the client, hey, they got a number back to us quick. It seems like they want to get this case settled today, and they can get us the check in a week. That's a powerful motivator to get the case moving. But it takes someone looking at the demand packs and picking up the phone and being available to resolve the claim. That's, I think, the best way to do it. And then you're going to get the claim done a little cheaper, maybe because you were so efficient with it and nice.
Yes. I think that's a good theme is, you attract more bees with honey.
Yeah. And like, hey, if I can tell the client they can get the check in a week, as opposed to like, I'll get the release to you and it takes a week to get the release, and then you wait the 20 days to get me the check. I'm like, hey, add a cherry on top of the number. Like, say, you get the release back. I'll have the check for you overnight to tomorrow. Okay. Clients love that. Yeah. And we love it because it just moves the files along.
And also, I think another thing that, people need to keep in mind is you also work off of like recommendations. Like, if you have a client that has a very positive experience like that, they're going to be a repeat client for you. And not that like I'm in the business of making sure you get repeat clients, but it makes you look good. So that makes you happier. So then the next time you might deal with that insurance company or that attorney, you might be, a little more, not forthcoming, but even more open to talk about things early on and try to get things done at a reasonable number.
Agreed. I mean, there's adjusters that I'm like friends with now outside of work, and I've never met them in person. I've only talked to them on the phone, and like someone's like offered to pick me up from the airport, like because we just have this rapport now over however many years, and they don't give away the cases and I don't give away the cases, but we get cases done because there's a credibility that we built in that my case is what I said it is, and their number is what they say it is, and we can get things kind of wrapped up.
Yeah. And that's got to be so refreshing for you too, to streamline it and not have to run through all the hoops too.
Right. It's like the non-robotic, like, be a human, like, just like get to the point, like talk about anything but the case. Offer me your number and we'll talk about like the NFL playoffs or something, but like the case is the case. Like, we don't need to talk about that anymore. That, I guess, would be like my biggest thing to adjusters, like, be responsive, like understand that we know our files and we don't need to be taught them over the phone. Like, that's it. That's how you get hung up on. Like, just get to the point and see if we can resolve it. If we can't, we can't, but no harm, no foul.
Yeah. Well, I thank you for so much for coming on. And I would say you approached me, which I love. Like, that's the best guests I ever have, is the ones that are like, I want to be on.
I wanted to be on. I'm like, I want to be like a podcast star like you.
I'm not quite there, but I'm working on it. But for our listeners and viewers out there, let them know where they can find you, in case, you never know. they might have cases with you, or they might have someone that they know that, was injured, and they might want to have a referral for you.
We've actually gotten quite a few cases from adjusters referring cases to us.
That's great.
Just from like our interactions with them. Yeah. So you can reach me. My name is David Kwalter. You can reach us at kmfirm.com. That's our domain name. And then my email is just my name, my first initial, last name at kmfirm.com. Yeah. Anytime there's any questions. Another thing is whenever there's someone's in a case and they don't think it's a case, it may be a case. And if you're hurt and you want someone to take a look at it, we're happy to do it. And the worst thing that we could say is no, and it's no harm. We're not offended if it's stupid. There may be something that we've touched that seems unreasonable, but we handled the case 5 years ago. So
yeah, that's such a good point, because I think a lot of people shop cases around to their family, and then they don't actually get a real opinion on it.
Yeah, and if you have a case, go to a personal injury lawyer. Don't go to your lawyer they handled your will, because though they may take the case, if they're not in the personal injury space, they don't really know what's going on. Just like I wouldn't write a will or handle someone's divorce, they shouldn't be handling our cases. And I think that happens a lot, unfortunately. It's a disservice to the clients.
Yeah, I will say some lawyers are guilty of thinking that if they're a lawyer of all things, and that is certainly not the case.
No, it is not. Unless you got hurt, I can't help you.
Well, Dave, thank you so much for coming on, and for all my listeners and viewers, again, if you like what you hear, please like and subscribe to the Defense Never Rests on Apple Podcasts, as well as you can find us on the Defense Never Rests podcast on YouTube.